I am Hüseyin Coşkun. I am attending from Turkish Competition Authority from Turkey. In fact, I have two questions to Mr. Fayez and Madame Fleur. Mr. Fayez, you have talked about the 10% rule in Hungarian competition law. Is there an example of the otherwise? I mean, is there a company that proves the degree is lower than 10%? Is there an example for this? And a general question, more general question than this. You have talked about the criminal execution in Hungarian law for competition. In Turkey, there is also debate about the subject, the main purpose or the main execution channels of criminalization. So I really wonder the other examples of this situation. How do you coordinate between administrative branch and the judicial branch? This is one of the top bargaining point for our country. And Madame Fleur, I think I missed the point that you talk about self-incrimination. I could not follow you very well. I kind of request you to repeat that point. You talk about a cartel and you get information by the way of self-incrimination, I think. I missed the point for that cartel. Please repeat it for me. Thank you very much.
Go on. Do you want to? Yeah.
Thank you very much. As to your question, whether there is an example of a cartel causing a harm of less than 10%, that's what I hear from all my clients, actually. They certainly have not caused 10%. In fact, in most cases, what I hear is that the surplus is minus, so they have, in fact, suffered. But there are a number of cases in front of the courts where the 10% presumption, which is a rebuttable presumption, though, is not yet applicable. This was introduced 2 years ago. There are cases which started earlier than that. In those cases, the plaintiff side has to come up with evidence which is in accordance with what the European Commission should be in accordance with what European standards are and what the Commission advises. And in those cases, we think those cases, at least those where I'm involved, have not yet entered the phase where the plaintiff have had to submit actual evidence on damage other than asking for an expert to be appointed, and then the expert is working. And there are, in fact, 2 cases where the expert has already provided its expert opinion. I don't think I can say anything further on that. But there will be cases where there will be judgments, they will be public, and where the court will have to decide whether the evidence adduced by the plaintiff is sufficient, is robust, is the right methodology of calculating the damages, the delta between the actual price and the would-be hypothetical competitive price. That will happen in a couple of cases. In all other cases, the 10% rule will apply, and it's still to be seen whether it will be just a simple switch of the sides, now that defendants producing evidence that the harm is less than 10%, again bringing economics experts, providing robust evidence on a number that is less than 10, or whether these cases will tend to settle. I have a feeling that they will tend to settle, because the plaintiffs have such an advantage that defendants will have more incentive to settle the case. Provided that plaintiff side lawyers behave reasonably, this is a chance. Your other question was about criminalization, in, I think, a bit more general than we would wanted to touch upon on criminalization. There are, as I said, I think 7 investigations in Hungary in the pipeline, all done by the police at this stage. No case entered the phase where public prosecutors would have charged individuals and would have brought them in front of courts. So I cannot, unfortunately, all I know it from informal sources, that there are, I think, what I was told some time ago, it was 7. I don't think there are new cases, but it is this. And what I hear from, again, from the authority through the graveyard, that they in fact, the the cooperation is not very optimal between the competition agency and the criminal authorities. So it is still to be seen whether the police and the public prosecutors will have sufficient means, and also whether they will be able to cooperate with the authority to understand what an infringement is in terms of competition law. For them, it's a lot of novelties they have to understand. This is still open.
Okay, excellent. Thanks, Gabor.
And just shortly to answer to your question, the self-incrimination statements were mentioned just to show how in majority in early cases, cartel cases, that there is still that the cartels are still viewed among the undertakings as something that is okay, and competition advocacy and policy have been made, and changes have been made, and there is a progress in that they are becoming more aware of that this is infringement of the competition laws, but until you find them very severely, it's still just a policy and a statement.
Well, okay, thank you. But I think that's the general sort of approach, really, that's changing. Companies become aware of the fact that this is a serious infringement, and they tend to treat it as such, generally speaking. Okay, we've kept you away from coffee for too long. I appreciate that. How long will we have to take the black stuff?
10 minutes.
When shall we sort of reconvene?
I think. Thank you, Mark. Thank you, guys. It was a great panel.
Yeah, we needed you for that.
I think. Let's be democratic. I think half an hour, or shall we assume?
Let's have 20 minutes.
Huh?
20 minutes.
Let's 20 minutes.
20 minutes, which basically
20 minutes.
Will.
And Gabor,
Yeah.
I'm fascinated. How do you know all that stuff? When I travel next time to Hungary, I have to call you in advance. He knows how many criminal proceedings are in pipeline.
Okay.
Thank you.
Thank you.